Welcome back. In this video, we're going to be talking about the material related to third-party rights in contracts. Up to now, we've been talking about two parties entering into a contract, whether their contract exists, and issues that affect the parties to the contract. But in this chapter, we're going to take a broader look and ask, can a third party, someone outside of the contract, ever enforce its terms? And before we get to that and answer those questions, though, I will give you my lawyer joke of the week. And this one goes like this. There was a man who absolutely hated lawyers. In fact, he couldn't stand them to the point where he would try to run over them on the sidewalk whenever he would see them. In fact, it was an instinct by this point in his life, and whenever he would see a lawyer on the side of the road, he would just instinctively swerve his truck over and try to run him over. And one day this man was driving down the highway, and he saw a car that was pulled off to the side, and he decided to stop to see if the driver needed any help. So he got out, and he noticed that the driver of the car happened to be a priest whose car had broken down, and he asked the priest, do you need a ride into town? And the priest said, yeah, that would be great. And so he got the priest in the truck with him, and they were driving into town, and as soon as the man was driving onto where the city streets began, he noticed out of the corner of his eye a person that he recognized as a lawyer walking down the sidewalk. And so instinctively, he swerved the truck over to hit the lawyer. But he stopped himself at the last minute because he realized next to him in the truck was a priest. And so he swerved to miss the lawyer at the last second, but he still heard this loud bang noise. So he pulled the truck over and he decided, I'm going to have to confess this right now. And there's a priest in the truck with me. He says, I've got to confess something. I absolutely hate lawyers, and it's just an instinct in my life at this point to run over them whenever I see them. And as he was explaining this, the priest interrupted him and said, oh, that's okay. I got him with my door. So, our opinion of lawyers aside, let's talk about third-party rights, okay? The first issue that is brought up sometimes with third-party rights is, can a third party ever enforce a contract to which they are not one of the original parties? And they might if they're a third-party beneficiary. And on the slide here we see a third-party beneficiary is not a party to the contract but stands to benefit from it. The question is raised, can a third party ever enforce a contract to which they're not a party? The general answer to this is no. Usually, a person has to have what's called privity, and that's a term that I didn't include on the slide. But privity of contract is this concept that only the parties to the contract can enforce its terms. For instance, if I have a contract with you to paint your house, and you're going to pay me $500 in exchange. If I paint your house and you don't pay me, I could sue you to enforce the contract. The question is, could a third party come along who's not me or you and sue you? Could my brother, for instance, sue you for the $500? And you might think, well, we did have a contract and you didn't live up to it, and so it was a breach of the contract, but my brother wouldn't have what we call standing to bring that lawsuit. He's not the one that suffered the injury. He doesn't have privity of contract, and so normally the law would say no. Only the parties to the contract can enforce its terms. That would be me or you. There are some exceptions to that, though, and that's what we're looking at here in this chapter. Our exceptions are going to be third-party beneficiaries and situations where there's assignments and delegations. Let's take a look at third-party beneficiaries first. So the question, can a third party ever enforce a contract that they're not a party to? And the answer is yes, if the third party is an intended beneficiary. And either, and we have some elements here, enforcing the promise will satisfy a duty of the promisee, or the promisee intended to make a gift. All right, so there's some terms we need to be familiar with before we really go any further. And I'm going to run through these terms, and then I'll give you some examples to kind of clarify them. First is a term called an incidental beneficiary. This is someone who the parties to the contract did not intend to benefit when they made the contract. An incidental beneficiary is not allowed to enforce its terms. And then we have a creditor and a donee beneficiary. And I want you to think of both of these sort of together because the result is the same. A creditor beneficiary is a person to whom the promisee owes a duty. And a donee beneficiary is a person to whom the promisee promises a gift. both creditor and donee beneficiaries are allowed to enforce the contract. So let me give you an example first of a donee beneficiary, because I think that's probably the easiest to understand. And I'll use the example of a life insurance contract. So let's assume I have a life insurance contract with a life insurance company where I pay them premiums every month or every year, and in exchange, they cover my life, and when I die, they will pay out a certain amount of money to whoever I list in the policy. In fact, that person that we list in the policy is called a beneficiary. So let's assume that I list my brother as the beneficiary. Now, in this policy, there's also some language that says that if I die in an accident, if my death is accidental, then the policy will pay double the amount. So let's say it's a $100,000 policy. So if I die in an accident, it would pay out $200,000. And there's also some language in the policy that says that if I intentionally or recklessly cause my own death, like through drunk driving, etc., then the company refuses the accidental death portion, and they won't pay it. So let's assume that that happens and I die in a traffic accident. The insurance company claims that I was drunk while I was driving, and so therefore they refuse the claim to pay the accidental death portion. And they pay the $100,000 regular policy amount to my brother as the beneficiary. And the question is, could my brother challenge the insurance company in court? Could he sue them in order to enforce that accidental death provision? And the answer is yes, because he would be an intended beneficiary. In fact, he's a donee beneficiary of the contract. Now, does he have privity of contract? No. Privity is only between me and the insurance company. But he did have an interest or a stake in the contract because he stood to benefit from it. In fact, he stood to benefit from it from the very beginning. And that's what makes him an intended beneficiary. Both me and the insurance company intended all along that he would be the one to benefit. And so he would be given standing to enforce the contract. Now, that is as opposed to an incidental beneficiary. Sometimes a third party will benefit from others' contracts, but they weren't intended to benefit. So I'll give you a quick example of this. Let's assume that we have a hypothetical Midwestern town. We'll call it Macomb. And this town owns some land, 10 acres or so, on its east end, and they own the land in order to entice a business to come and build a factory there and employ a lot of its citizens. And so the land is fairly cheap and has a lot of incentives attached to it. And so let's just say that there's a hypothetical manufacturing company, we'll call them Pella Windows, and they decide that they want to buy the land. So Pella and the city of Macomb sign a contract to buy the land and sell the land. Well, there are some beneficiaries that are going to in fact benefit from this contract because Pella is going to buy the land, build a factory, and employ approximately 500 people. And about a quarter of a mile away from this land that's the subject of the contract sits Walmart. And Walmart is very excited about this contract and the proposed factory because they know that's 500 more people a day that will drive past Walmart going to work and drive past Walmart going home from work. And as we all know, you don't drive past Walmart, you have to drive into Walmart, and you have to spend $110 every time you go, right? And that's what I call the Walmart principle. But Walmart will in fact benefit from this contract. And let's say that they've worked it out, and because of the increased traffic, they stand to benefit by, $100,000 more in profits every year as a result of this. Okay. So there's an economic downturn, and Pella decides they're going to back out of the contract to buy the land. They're not coming to Macomb. They're not going to build a factory. They're going to breach the contract. In fact, they tell Macomb this. They say, well, we're sorry, but we're just not going to buy the land. Now, the city of Macomb could enforce the contract. They could sue. Maybe they would have some damages that they could prove, and they could end up going to court. But the city decides, we really don't want to sue Pella. We don't really want to bring a lawsuit because then they could have hard feelings against us, and then, maybe the economy will pick up and they'll change their mind later. But if we sue them, they'll never come to town. So they decide not to do anything about the breach. And the question then is, can Walmart sue Pella for breaching the contract? And the answer there is no, because they're an incidental beneficiary. Yes, they would in fact benefit from the Walmart and Macomb contract, but they were not intended all along to benefit. Walmart and Macomb did not have, I'm sorry, Pella and Macomb did not have Walmart in mind when they made the contract. Okay, so let's take a look at some other exceptions to the privity rule where people can get rights or obligations under contracts, third parties can. Let's take a look at the situation of an assignment first. An assignment is a transfer of rights from a party to a contract to a third party. Okay. I like to explain it this way. An assignment is where you take what you're getting under the contract and you give it to someone else. So if I have a contract with you, I'm going to paint your house, you're going to pay me $500. I'm giving painting services and I'm getting the payment of money. I can take what I'm getting under the contract, the payment of money, and I can assign it to a third party, give it to a third party. Okay, that's what an assignment is all about. It's transferring what you get, your rights in a contract, to a third party. Okay, and if I make a valid assignment, that third party then has the right to enforce the contract against you if you don't pay. So let's assume that I go ahead and I paint your house, and you don't pay me, and you don't pay my assignee, you just don't pay anything. And I, let's say, am gone or don't really care whether you pay or not because I've already assigned my rights to a third party, so I leave and I'm in Mexico. The question is, can the third party, the person I assign my rights to, can they sue you? Well, they don't have privity, but if they do have a valid assignment of the contract, then yes, they can sue you. They can enforce the rights of that contract. So let's take a look at when that exists and when it doesn't. The right to receive a benefit under a contract is assignable, generally, unless one of these three conditions exists. One, it would substantially change the obligor's rights or duties under the contract. Okay, and here's my example. You can see I've got this crude little diagram here, but let me put some facts to it so you can understand it. Let's assume that I have a contract with Professor March to mow his yard, and I'm going to mow once a week, and he's going to pay me $50 each time that I mow. Okay, and that's our contract. Well, let's say that Professor March and President Thomas, who's the president of Western Illinois University, they see each other at a reception and they start talking about lawn care and landscaping, and President Thomas says, you know, it's really hard to find somebody that's reliable that'll show up to mow my lawn all the time. And March says, oh, I know. He says, I have Hunt under this contract to mow once a week for $50. Why don't I just assign my rights in that contract to you? He's talking to President Thomas. So he takes what he's getting under the contract, which is mowing services, to mow his yard, and he transfers those to President Thomas. Well, you're not familiar with Professor March or his yard, but let's assume that it is a 1-acre lot, and I've agreed to mow a 1-acre lot every week for $50. March then assigns his rights in the contract to President Thomas. And you may be familiar with the president of the university's house here at Western, but his yard must be no less than 5 acres. So the question is that a valid assignment? And what would that mean? If March could assign his rights in the contract, and when he's getting his mowing services, he could assign his rights to President Thomas, which would mean that me, the obligor, that's what we call me under the contract, because I'm obligated to perform, I would have to go mow President Thomas's lawn for $50. Does that seem fair? Does that seem right? Oh, and by the way, an assignment doesn't need my consent. An assignment is valid even if the obligor doesn't consent to it because it's the rights that a person is receiving under the contract. Well, the answer there is no. That's not a valid assignment because of our first category. It would substantially change the obligor's rights or duties under the contract. It would substantially change what I had to do under the contract by a multiple of 5. And so no, that is not a valid assignment. And from that category, from that rule, we get this sort of bigger or blanket rule that we have listed there that you can't assign personal services contracts generally because you run into the same problem all the time. So we have this rule now that if what you're getting under a contract is personal services, mowing services, painting services, accounting services, legal services, whatever it is, you can't take those receipt of services and assign that to a third party. That's an invalid assignment for the reasons that we've stated there. Okay, the next category is if an assignment is forbidden by law or public policy. Okay, if the law says you can't assign certain rights under a contract, well, then you can't. And obviously, we're not going to violate that. One example that I thought of is tort claims, at least personal tort claims. If you're hit by a drunk driver, for instance, you could sue in civil court for money damages. And the question is, can I take my right to sue that person and assign it to a third party? And most jurisdictions have rules that say, no, you can't do that. That's a personal claim. Because otherwise it would create a class of professional plaintiffs who would go around buying up other people's lawsuits to try to profit from them. And that's just not a good idea. It violates public policy, so we don't allow that. And then last, unless the assignment is precluded by the contract itself. So it's valid unless it's precluded by the contract itself. If the contract says no assignments, then no assignments. Although we'll find out when we talk about the UCC especially that sometimes courts tend to ignore that one and allow assignments anyway. Okay, so how do we go about doing this? What's required for a valid assignment then in terms of the procedures? How are rights assigned? What about a writing? Do you need a writing? Can you have an oral assignment, and is that valid? Do you need a writing like the statute of frauds? Well, the rule says that a writing is not required unless the original contract that you entered into that you're now assigning the rights on is subject to the statute of frauds. So if the contract under which you're assigning your rights is subject to the statute of frauds, then your assignment must also be in writing. What about consideration? Is an assignment of rights valid if the other side isn't giving consideration in exchange for that assignment? Is consideration required? No, it's not. If consideration is received, however, in exchange for the assignment, then the assignment is irrevocable. And that's because it's really a separate contract, right? So a lot of times we do this. A good example of this would be a financing company. I don't know how many of you have purchased furniture lately, but a lot of times you'll see these ads where the furniture store will have a deal. This is, you buy this furniture and you make monthly payments, and a lot of them will have incentives. Your first payment's not due for 18 months or something like that. So you go down to the furniture store and you sign a contract. You get the furniture and you agree to pay monthly payments of a certain amount plus exorbitant interest until the whole obligation is paid off. Well, the furniture company typically doesn't just keep that obligation. Usually after you purchase furniture, or sometimes even a car or some other items with a larger price tag that need to be financed, the seller will then, like the furniture store, will then assign their rights to receive your monthly payments to a bank or to a finance company. And in exchange, the finance company or the bank will pay them a lump sum of money in exchange for that assignment. So the bank will pay a certain amount to get the assignment. The furniture store will make the assignment, and then you, the obligor, will make your payments directly to the bank or to the finance company rather than to the furniture store. And that's a good example of an assignment. But if the bank pays the furniture store for the assignment, well, then that makes the assignment irrevocable, because really that's a contract, separate contract. And the consideration that the furniture store is giving is the assignment. If no consideration is received, however, then the assignment is revocable. So if it's just a gift, right? If I'm assigning you the rights in the contract just because I like you and I want you to get, my rights under this contract. I'm going to paint your house. You're going to pay me $500. I paint your house and I assign my rights to the $500 to my brother just because he's my brother, and he's not giving me anything in exchange. I could revoke that, right? Because that's a gift. There's no consideration received for that. Okay. There's one wrinkle here about the rule. If the assignment is gratuitous, in other words, there's no consideration received, it's a gift, but I make it in writing, then it's irrevocable. Okay, so if I'm going to paint your house for $500, I'm going to assign my rights to the $500 to my brother, and I make the assignment to my brother in writing, even though it's gratuitous, I'm going to be stuck to it. It's going to be irrevocable. What about a writing or any kind of notice to the obligor? Do I need to do that to make an assignment valid? And the answer is no, it's not required. It would be a good idea. And a lot of times, like in my furniture store example, if you're the consumer and you go to the furniture store and you sign the installment sale contract and you agree to make monthly payments, the furniture store then will assign their rights to a bank, and then they will send you, the customer, notice of the assignment. They'll tell you, we've assigned our rights in this contract. Now make your payments directly to the bank who's received our assignment. Okay, so what does this get us then? If we're the assignee, if we're the one receiving the assignment, what does that entitle us to? Well, the law always likes to say that the assignee stands in the shoes of the assignor. And that's another way of saying that the assignee has all the same rights and obligations that the assignor would under the contract. So if I like to use simple examples. If I contract with you to paint your house for $500, if I assign my rights in that contract to my brother, he would have the same rights to collect that $500 that I would. He would have the same standing that I would. However, he would also be subject to the same defenses that I would. So if I painted your house, but I did a terrible job, and you claim that my performance was not even substantial performance to the point where I breached the contract, you're going to have the whole house repainted, so you owe me nothing, is what you're claiming. Then he would be subject to that defense. If he tried to sue you to collect the $500, you could claim the defense of breach or insignificant or unsubstantial performance. Also, when an assignor assigns rights under a contract to an assignee, there are certain promises that go along with that assignment, right? That's what we call the assignor's warranty. By the way, anytime you see the word warranty, that's just another way of saying a promise, right? The assignor, when they make the assignment, warrants a couple of things. One, that the rights that he or she is assigning do exist. So when I make my assignment to my brother, I am promising him that I do in fact have a contract with you to paint your house. That's one. And two, that there are no defenses. So when I make the assignment to my brother, I'm claiming to him, or I'm promising to him, there are no defenses that you have to my performance. So if you do raise a defense and you're successful, then I might have to make that up to my brother, because I'm basically promising him, yeah, I'm making this assignment and there are no defenses to it. Okay, one promise though that we don't make automatically as part of an assignment. The assignor does not warrant that the obligor is solvent. Okay, what does that mean? That means, back to my furniture store example, if the furniture store makes an assignment to the bank of the customer's payments, they are assigning to the bank, or promising to the bank rather, that the contract with the consumer does exist and that the consumer has no defenses to the payment. But what they're not promising is that the consumer has enough money to make the payments. They're not promising that the obligor, the consumer in that example, is solvent. Okay, let's talk about the UCC and how it treats assignments real quick. The UCC favors assignments. In fact, there are general anti-assignment clauses are construed only to mean that a party may not delegate duties, but assignments of rights are still allowed unless specifically stated. And even then, sometimes under the UCC, courts will allow assignments. So what does that mean where I just talked about that? Even if in the party's contract, the parties say no assignments, then a court will say, well, they really meant no delegations, so assignments are still okay, right? The UCC really favors assignments and will enforce them whenever they can. What about, there's one instance that comes up though, the one issue in the UCC that has to do with something called a waiver clause. I want to talk about that and give you an example of that. Waiver clauses under the UCC are valid. What is that? Well, under a waiver clause, the buyer usually of a good, and we're under the UCC, so we're talking about contracts for goods. The buyer agrees that he or she will not raise any defenses that he or she may have against the seller against the assignee. And we agree to this in the contract. Waiver clauses usually are not enforced in a consumer transaction. But if it's a commercial transaction, then a court will. Okay, let's take a look at one of these so you can see what I'm talking about. And we have some figures there on the slide, and I have just a set of facts here over to the side. So let's take it a step at a time. We have Dave's Auto Body, and Dave's is going to lease a piece of equipment from Fastenal. It's a hydraulic pump. Okay, so they're going to execute a lease, which is a contract, right? And the lease contains what's called a waiver clause. And a waiver clause is where Dave's Auto Body says that they agree that if Fastenal assigns Fastenal's rights, that Dave's Auto Body agrees not to raise any defenses to whoever Fastenal assigns their rights. So let's take it one step at a time here. Let's say that they execute that lease. Dave's Auto Body gets the pump, and the pump breaks or fails to work correctly. Fastenal then goes out of business. They're bankrupt, right? Dave's Auto Body takes the pump back there to say, hey, I'm returning this pump. It doesn't work under the lease. I'm not going to make any more lease payments, obviously, because the pump that I'm leasing from you doesn't work. I have a defense to the payment. Fastenal, however, says, well, we don't have any obligation. In fact, their store is boarded up, and they've just gone out of business completely. So when Dave shows up with his broken pump, there's nobody to even talk to. He doesn't know what to do with it. However, he gets a statement from a finance company because Fastenal has assigned its rights to Dave's Auto Body's payments under the lease to the finance company. So Fastenal executed an assignment to give the finance company what they were supposed to get under the contract with Dave, his monthly payments. So finance company sends Dave's Auto Body a statement saying, yeah, your monthly payment is late. And Dave, of course, says, well, wait a minute. The pump that I'm leasing is broken, and so I'm not going to pay for a broken pump. Finance company says, we don't care, because you signed a lease that said you would not raise any defenses against Fastenal's assignee, that's us, that you might raise against Fastenal. And so we're basically entitled to the payments no matter what. This is the effect of a waiver clause, and a court would enforce that. Of course, the finance company would have to show that they took the waiver in good faith and without notice of any defenses or anything like that existed. But a court would enforce it. It seems a little bit unfair, but the idea is that a waiver clause makes an assignment more valuable. In other words, the finance company is going to pay Fastenal more for that assignment because it comes with no defenses. And so the UCC recognizes that and will enforce that. So watch out for those.